James Lee is partner and financial advisor of Metropolitan Wealth Advisors. James has 22 years of experience in the financial services industry. His areas of expertise include asset management and financial planning. Metropolitan Wealth Advisors is a wealth management firm that specializes in helping people tackle everyday financial goals, offering planning for retirement, tax planning, life insurance, estate planning, and asset management. This morning, James will present his session titled Estate Planning, a Sensible Approach.
Okay, thank you very much, John. Looking good this morning. Good morning, everyone. Thank you for attending Wills Week and for our session on estate planning, a sensible approach. I provide a lot of financial education for different divisions for University of Maryland, and so I've been doing this for quite some time. And one of the agreements that we have with the University of Maryland in general is that in providing workshops like these, we want to be able to bring an additional benefit. So in discussions with John, it's one thing to learn about estate planning, but what's really important is understanding how it affects you individually. So I have agreed that absolutely, without any question, I'm here to answer any individual questions that any of you may have. You can email me, you can call me, whichever way you want to do it. And for some people, we even will provide complimentary estate plan forecasts. So you can look at your situation and see what it looks like overall, which in turn will help you determine the moves that you need to make. So let's get started. Today, we're going to talk about estate planning in general. What does it mean to you? The permanent, I like to call it the permanent temporary estate tax law, and today's estate tax landscape, as well as 10 common mistakes that people can avoid. So what does estate planning mean to you? It's interesting, over the years, as I've spoken to people in regards to estate planning, many in the past have looked at estate planning as something that was just for people of means, people who are wealthy. It's something that we saw on TV, that there are trusts or whatever the case may be. We've heard about it in the news. But really, when it comes to estate planning, it involves every single one of us. Because when we look at estate planning, we really should be thinking simply organization. We need to be organized. So there are different reasons why people may want to do estate planning, though. It could be determining who's caring for children. I can tell you, and we're going to go over this a little bit later, but when it comes to doing your will and setting up your guardianship, if you have young children, that's a big sticking point that freezes some people from getting the wills done because they can't determine who the guardian for the children's going to be. Structuring your estate for your finances so all of your loved ones are taken care of in the proper way, strategizing the best way to minimize the cost of dying, not paying any unnecessary taxes or fees, establishing who is going to handle your finances, making sure you're picking somebody who's the most reliable, as well as making medical decisions on your behalf, and of course, the beneficiaries. Can the beneficiaries handle the estate, and is it something that you want to provide for them in a lump sum? So everybody really does need some level of estate planning. So it's not almost everyone needs some estate planning. I believe everyone needs estate planning. So in going over various examples, you can see here, parents with young children, obviously they want to have guardianship there. If you have spouses with children from former marriages, whether you want to include them or exclude them or split it up, these things have to be put in writing. Grandparents who want to make sure that the grandchildren receive the funds as opposed to any other family members. Business owners making sure that their business is passed on to the right children who are going to run the business or split up properly among whoever the heirs are. And of course, if you're an individual who has a special needs child, then you want to make sure that they do not receive any assets under their name, as you don't want to interrupt any benefits that they may be receiving. So let's look at the permanent estate tax law. Again, I say permanent slash temporary because at the end of the day, it just depends on who's in Washington. So as it stands right now, we're going to move forward here. I apologize for the delay. So let's take a look back. Now, it goes back to 2011, but do any of you remember what happened in 2010? In 2010, the estate tax was repealed because it just wasn't addressed. So of all the years in the history of the United States, 2010 was the best year to die. Just so you all know that, but we're past that, so it's kind of too late for everybody. But since then, the estate tax limitation was brought back. So what is the estate tax limitation? It is the amount of which you can leave above the threshold. And the amount above that threshold, you will pay estate taxes. Anything below that threshold, you do not pay federal. Now, I want to make sure I emphasize that. You do not pay federal estate taxes. So in 2011, 2012, the top tax rate was 35%. 2013 and beyond, top tax rate is 40%. And again, depending on which administration is in office, it could be more or it could be less going forward. And in 2020, the exemption, which is the amount that you can leave without paying any federal estate taxes, was $11,580,000 per person, or as a couple, it was $23,160,000. Now, you may be looking at this and think, well, maybe I don't quite have 23 million right now as a married couple, and that could be understandable. However, remember the temporary part that I had just mentioned, because when it comes to estate taxes, it is very likely that at some point down the road, this number will not hold. This could very well come down. I think one of the proposals that are out there is that this could potentially come down to $7 million. Now, the $7 million includes all of the assets that you have, including your home, including life insurance, and then inflation adjusted. I think you would be surprised at being able to reach that number in the future. Then if we look at the various states that are out there, so one thing is to have the federal estate tax, but depending on the state that you live in, there could be some additional taxes as well. So let's look over here to Maryland. So in looking at Maryland, we do have a state estate tax, and we do have what's called an inheritance tax. So in the state of Maryland, they were going to follow the federal government in increasing the estate tax limit, so the amount that you can leave without paying any estate taxes. But the federal government went well past 5 million. So the state of Maryland said, hold on a second. We're going to cap ours at 5 million. So anything above 5 million that is in one's estate is going to be estate taxable in the state of Maryland. And that can be as much as 16%. So anything above the 5 million can be taxed at 16%. But what about the inheritance tax? So the inheritance tax is paid by the person who receives it. The estate tax is paid by the estate prior to distribution. So what's the difference? The inheritance tax really only applies to non-family members. So if I leave something to my sister, or if I leave something to my children, they're not going to pay inheritance tax. But if I leave something to a distant cousin, or I leave something to a friend of mine, then they will, in fact, pay inheritance tax, and that can be 10%. So let's address some common mistakes that are out there in regards to the estates. And the first is, of course, making a plan. You know, we want to make sure that it's laid out, that our wishes are laid out and put in writing in the proper way. Secondly, you know, you want to avoid assets passing to the wrong heir at the wrong time in the wrong way, because If you want to have, you may have minor children, and then until they're grown, you want to make sure that the money doesn't go straight to them, that there's some sort of structure in how they receive the money, and that's okay as well. But whatever your wishes are, I think that it's important to make sure that they're carried out. Because again, with any of these documents, as time passes, you're definitely going to make changes because the situation changes. And then working with a team that includes financial advisors, tax professionals, and estate planning attorney to make sure that everything is coordinated in the correct way. So number two is the documentation. So what is it that we need in the estate planning process? So every single one of us, we need a basic will, period. So what is the will? We'll go over the exact explanation of what the will is in a moment, as well as the rest of these items. But the basic will is something that you don't necessarily have to have an attorney do. Nowadays, you have online documentation. I think in the state of Maryland, if you have two witnesses, then it's a valid document. Now, I'm not recommending that that's how you do it. You could use an attorney if you like. But I always feel that it's better to have something rather than nothing. Then there's a healthcare power of attorney. We need to have the durable financial power of attorney, the living will, and of course, the HIPAA form. So let's look at a will. So in essence, the will is telling the probate court who my rightful heirs are. So when someone passes away, the state handles the probate court. So the state is trying to determine, okay, this person passed away. Who are these assets or this money supposed to go to? And if you don't have a will, then they have to determine who that person is going to be. And I'm going to elaborate on that in a moment. But if you have a will, you take the will to the probate court. You walk the will through probate. They see the documentation. The will says, okay, these are my rightful heirs. They see that it's validated, stamp it, boom, you're good. And you also need to name an executor for your will or a representative. Now, before you do that, I'm sure some of you have been through the probate process. Maybe it was an easy process, maybe it wasn't so easy. But more often than not, I hear the stories that were not that easy. So when you name the executor of your will, I wouldn't assume that you're necessarily doing them a favor because it's a lot of work. So before you do that, let's just make sure that that person is capable of handling that and willing to handle the probate process. I'm going to take a step back here. Now, making sure that specific items are in your will is also important, because in some circumstances, and I've seen this quite a bit, where there may be certain pieces of jewelry or very specific collectibles that you want to have go to one child versus the other, and or one heir versus the other. And I think, again, that's something that you would put in the will, and just having everything in writing makes things so much easier going forward. So back to the executor. What would the executor do upon passing? What is their role? They have to submit the paperwork. They have to take inventory of all of the assets. So if you don't have anything, if you don't have all of your assets clearly organized, then they have to figure out what and where everything is. And sometimes that entails waiting for mail to come to see what statements come in. Then they have to notify creditors of the passing, pay any debts that exist or outstanding expenses and taxes. After that, they distribute the property per the instructions of the will, and then they close it out. So as you can see, it could be quite a bit of work. And so again, you want to make sure that it's somebody who can handle it. Now, with all of these documents, you should have a primary representative, so the first person who would take care of things. and have at least two contingent executors or representatives. So just in case the first person can't do it, maybe the second person can't do it. But what if the second person can't do it due to whatever reasons? Then it would go to the third person. So it's wise to make sure you have a primary, then contingent. What we advise against is to have co-representatives with any of these documents. The reason why is because, believe it or not, some people will have differences of opinion. And sometimes it can be a little bit of a mess when you have multiple people that have authority and they can't agree on what to do or how to interpret your instructions, and thereby creating gridlock. So that's something that we definitely want to avoid if at all possible. Then there's the healthcare power of attorney. So who's going to make healthcare decisions for you? Is it going to be, now keep in mind, with all of these documents, if you are married or have a significant other, that person is generally going to be the first person, but we're talking beyond that. So beyond that, is it going to be another family member? Is it going to be children? I mean, I can tell you, and you can name different people as different representatives. I have 3 children. I have a daughter who's the oldest, and then I have 2 sons. And I can tell you that I definitely wouldn't have one of my 2 sons as my medical power of attorney. So I would leave that up to my daughter for sure. Well, I'd probably leave the financial part up to her as well, to be honest with you. But you can choose different people for different roles. So please keep that in mind. And then you have the financial power of attorney. So this is for when we're alive. Just in case, if you were, let's say you were to become ill, you have a good prospect of recovery, whatever the case may be, and you're in a hospital and you can't make financial decisions. Well, the financial power of attorney allows someone to make financial decisions on your behalf. So they could pay bills, they could write checks for you. All they have to do is submit this financial power of attorney document. People also use it if they travel quite a bit. So if I'm out of the country, my financial power of attorney can take care of whatever financial needs that may exist at home. But when it comes to the financial power of attorney, many people like to use what's called springing power. So on the financial power of attorney document, it says, so-and-so is my power of attorney, but it only becomes effective if accompanied by 2 doctor's notices stating that I'm incapable of making financial decisions. That's just a little protective strategy. So if somebody has that document, if it's a child, as an example, they just can't take that document and go out and start writing checks in your name. Hopefully that would never happen, but just an extra layer of protection. And then there is the living will. So I'm going to tell you a very personal story that happened a couple years ago. So my father, who is dealing with cancer right now, 2 years ago, he was hospitalized. He was in bad shape, so he was on life support for a period of time. And I have a very, let's just say, interesting family dynamic where I had his ex-wife as well as a current mate, let's just say. So we're all there in the hospital, and I have my sisters there as well, but I'm the representative for the living will. And the living will has very specific instructions that, he would want to be kept on life support for at least 30 days. So, okay, and that's my job, is to just follow those instructions. But meanwhile, here we are in the hospital room, and there are multiple people in this room that say, well, he said that he didn't want us to see him like this, and that we should relieve him of this situation immediately, on and on. Well, at that point, I had to remove everybody from the room because I am the representative, and I'm simply not going to be emotional about it, but follow the instructions that are in front of me. And so I did. Now, 3 days later, he did come out of that, and here we are 2 years later, and he's still alive. Unfortunately, he still has cancer, but he is alive. And the reason why I share that personal story is because I've been very familiar with these types of things happening, but experiencing it on my own, being in that room and that feeling of whether it's people trying to guilt you into a decision or convince you to make a decision, our job is to follow the instructions. And the best thing that we can do for the people around us is to provide those specific instructions for them to follow. And then there is the HIPAA release form, which is necessary nowadays. So if you have a representative, they need to be able to obtain your medical records, to be able to show a different physician or hospital. Of course, we have to have the HIPAA release in order for that to take place. So looking at the absolute necessary documents, to recap, we have the will, the power of attorney for the health care, who's going to make medical decisions for you, the durable power of attorney, the living will, which is primarily being on life support or fed through a tube, and then the HIPAA release form. Every one of these documents are what we all need to have this. And if you have that, it will be clearly in writing, clearly structured. You will feel much better. I always have a notarized copy, and I have whoever my representatives are, they have a copy of it as well. So in this example, they talk about Heath Ledger from the Batman Dark Knight movie. And whether you know him or not, he had passed away. He was an actor, passed away in 2008. And he didn't redo his will. And it was signed before his daughter was born. So everything was left to his parents and his sisters because that was on the will and probably on his other documents as well. So it took 5 years for the family to relinquish those funds to his daughter. And those are the types of things I hear again and again and again, because I see every time famous people pass away, there's an article done, within my industry. And it's interesting to me how many famous people with large estates, with all of these representatives around them, and yet they don't have things organized the way that they should. So one other area that is a real sticking point is the guardianship. So who's going to take care of our children when they're minors? Is it your parents? Is it my parents? Is it my sister, your sister, blah, blah, blah. And like I said earlier, that really becomes one of the main sticking points when you're somebody who has young children and trying to find that guardian. But the one thing that I can tell you is I still would rather name someone rather than no one and not have this document in place, just in case. And when it comes to the guardianship, you also have to remember, if you're a little iffy, if you're not sure about the person who's going to be guardian, or if you don't want that person to control money, that's okay. Because the person who has guardianship of the children doesn't have to be the person who handles the money as well. You can have that as a separate person. So things can be structured any way that you want for them to be structured in order for you to be more comfortable. Before I get into trust, there's something that I wanted to share with you in regards to the state of Maryland. What happens if you don't have a will? How does the state of Maryland determine who assets are supposed to go to? Now, if I'm married, obviously assets should just simply go to my spouse. But if I'm married with children and I don't have a will, what happens?
The recording has stopped.
So I'm going to review with you some examples of what happens in the state of Maryland.
This meeting is being recorded.
If I have a spouse and children who are minors and I do not have a will, the intestate succession rules in Maryland state that the spouse inherits half of my property and the children inherit everything else. Did you all know that? What about if I have a spouse and I have children, but none of them are minors? Well, the spouse, it's the same thing, but the spouse inherits 15,000 worth of the intestate property plus half the balance. The descendants legally receive everything else. If I have a spouse and parents but no descendants, the spouse inherits 15,000 worth of my estate plus half of the remaining balance, half of the balance, and believe it or not, parents inherit everything else. So this is really very interesting, and you don't necessarily see people take advantage of these rules that are out there, but they exist, and it's something that you have to be very careful of, for sure. Now let's go into trust. Why would I have a trust? And what's the difference between a will and a trust? So all those documents that you saw before, if you get a trust, they're all inside of the trust. Okay, so the will essentially will say, my beneficiary of this will is the trust. Okay, so everything goes to the trust. Now the trust is controlling how things are handled. And all of those other documents should be done as well. So I always like to say the trust states who the rightful heirs, the will states who the rightful heirs are, but the trust dictates who it goes to. So if you would like to be creative in how you leave money to heirs, you can certainly use a trust to do that. There are some people that feel that they would not like for their children to receive all of the money at one time. I've seen situations where they say, okay, they get 1/3 at 25, 1/3 at 35, 1/3 at 45. You can structure it any way that you like. My child doesn't get a dime unless they visit my grave every month. Whatever it is that you would like to do, that's probably something I would do, by the way. But whatever you would like to put in there, you can do it within the trust itself. So what are some of the benefits of a trust? The beneficiaries can gain quicker access to the assets. There may be less estate taxes depending on how the trust is set up. Retaining control in complicated situations with marriages, and I'm going to elaborate on that in a moment. Making sure that you protect legacies, and some assets are going to pass outside of probate, so you could save some court fees and such. But let's talk about the main reason why people are utilizing, that I see at least, people are utilizing the trust nowadays. The primary reason is because when you pass away, the funds that go into the trust, and let's say everything goes into a trust, the trust becomes a separate tax entity. So it has its own tax ID number. So it is its own entity outside of you who have passed and outside of your children who are the beneficiaries. Now, they're still the beneficiaries, so they can take money as long as you have that stipulated in the trust that says, well, they can take money anytime they want, then they can take money out of that separate tax ID number anytime that they want, no problem. Okay, so access is not the issue. But while the funds are in this separate entity, if, let's say, they were to get divorced, well, it's not their estate yet. It's not part of their assets yet. So the ex-in-law would have a difficult time trying to attach that money. And then also, so they want to protect against divorce and creditors because it's not your children's yet until they take it out. And then also, many people I find are doing the trust because due to that nature, that it's a separate tax entity, they want to make sure that the assets are protected for their grandchildren. So something can't happen, like the parents get divorced, they split up the money, they use up all the money, and it doesn't go to the grandchildren. You can have the grandchildren direct beneficiaries as well. So that's one of the primary reasons that I'm seeing trust utilized right now, is really to protect against creditors and divorce, to make sure that the funds stay within the lineage. So the grantor sets up the trust. The beneficiary is the recipient of the assets of the trust. And then, of course, there is the trustee. Many people would have the executor of the will. And if you're going to have a trust, the executor of the will and the trustee is the same person because, in essence, they're doing very similar duties. So I'm not going to go over every trust that exists. But as you can see, there are many different types of trusts depending on what it is that you would like to accomplish. So that's something that a discussion that you can have with an attorney. Any competent financial advisor should be able to at least guide you in the right direction in regards to which one of the trusts fit your situation the best. So in going through this process, I mean, some of the basics that we have to remember is that there are different state laws, and we saw that with the estate taxes and the inheritance tax. So if you move from state to state, let's say you have a will, because this is a common question that people have, do I need to redo my will? Well, that depends. You're going to have to look at the state that you came from plus the state that you go to and see whether that's something that is necessary or not. Now, if you're going to permanently reside in another state for the rest of your life, probably a good idea to go ahead and have it redone. And not only that, your will documentation, your power of attorney, all of those documents really should be updated every 5 years anyway. So, and then choosing and creating a trust, it's not that easy of a process. So you want to make sure that you're covering all bases, that you're not missing anything. And that's why whether it's, an advisor that deals with estate planning and the attorney, making sure that you have those conversations, that everything is covered, that you're not missing anything. And then making sure that your estate is structured in such a way that you can pay for any federal estate taxes. If we go back very quickly to that 2010 that I mentioned where there was no estate tax, there was one famous person that did pass away toward the end of that year. I don't know if any of you can remember, but it was Steinbrenner, the owner of the Yankees. Now, with him being as ill as he was, they knew that if he passed away as rich as he was, they were looking at selling the Yankees to create enough liquidity for estate taxes. But he happened to pass away at the end of 2010. Now, was that by design or not? Well, that depends on who you ask. But the reality is his family got the Yankees for free because they didn't have to sell it because he didn't have to pay those estate taxes. But if in fact it does come to the point where your estate is above the estate tax exemptions or limitations, then you certainly want to make sure that there's enough liquidity there. And then there are different strategies that can be utilized to reduce your taxable estate. That's something that you definitely want to look into for sure. And then avoiding probate. It's almost impossible to completely avoid probate because you have some assets that just aren't in trust name or whatever the case may, or don't have beneficiary designations. So I think it would be wise if you could put things in a trust, or again have beneficiary designations. And I'll give you an example. Your life insurance and your retirement accounts all have beneficiaries, right? And those beneficiaries bypass probate. Okay, so that's very important to know. If I have a bank account or a non-IRA stock account, I should have a payable or transfer on death on that account. All it is one piece of paper to sign, and you're just naming a beneficiary, which otherwise wouldn't be on there. If it's not on there, it goes through probate. But if it is on there, then it goes directly to whomever that beneficiary is. And then there's long-term care. So I mentioned long-term care because in this day and age, it's really the one thing that's out there that can reduce an estate or eliminate an estate. Planning for long-term care is very difficult because we don't know if we're going to need it or not. But I think most of you have seen the statistics that, in fact, a pretty high percentage of people actually do utilize or need some sort of care at some point in time, whether it's in the home or whether it's actually in a facility. So Again, that's something that we really should look at and try to plan for the possibility of paying for that care. Because in some circumstances, you may say, well, we have enough money, that it's not going to be an issue. But what we want to make sure of is that, yes, in fact, you have enough money, but not just for one of you, but for both of you. Because if the first spouse needs some sort of care and needs it for an extended period of time, they may utilize the majority of the assets, which means nothing's left for the spouse to get quality care. And we don't want to see a situation like that take place. Then there's income in respect of a decedent. So if you have, all of you who have 401ks, IRAs, you have to keep in mind that whatever you leave, whatever's passed on, your heirs will pay taxes on that money because you have not paid taxes on that money yet. So in doing the estate planning, what we've found is that a lot of the baby boomers have done an incredible job of putting money away into retirement accounts. So they've accumulated large retirement accounts. And then they retire and maybe they have a pension or they have other funds. And they say, you know what, I don't want to touch that retirement account yet because I don't want to pay the extra taxes if I take the money out. So I'm just going to leave it and let it keep growing. Then 70 and a half comes. I realize it's 72 now temporarily. It could go back to 70 and a half though. So at 70 and a half, now I'm forced to take the money out. So I've let it continue to grow, but now I have to take the money out. And not only do I have to take the money out at 70 and a half, but I have to take a higher percentage of that money each and every year from that point going forward. So if I don't really need the money, then it creates much, much more taxability to me ongoing. So we have people in their 70s and 80s in the highest tax bracket of their lives because they're forced to take the money out of the retirement accounts. And then I'm just taking the minimum. So hopefully the money's still growing, but I'm taking the minimum that I have to take out of my 401k or IRAs. But whatever is left there, if it's $1 million and if it goes to one child and they take that $1 million, they're going to lose 50% of it to taxes. The stretch IRA essentially is gone. Now it has to be done over 10 years. So they could take $100,000 a year over 10 years if you stretch it. They could be forced to take it over 5 years if it's coming directly from a 401k. But the point is, this will be added on top of their income. So if they're doing well on their own, this is going to add to that. So all of this is likely going to be taxed at the highest tax bracket. Keeping your beneficiaries up to date inside of your 401k and IRA and your insurance policies. So again, keep in mind that beneficiaries bypass your will. So if my will says everything goes to my spouse and I have an IRA, an old IRA that says it goes to my sister, well, if I pass away, that IRA is going to my sister. So aligning everything, your beneficiaries and who your heirs are in your will, or separating things on purpose because you want to leave specific assets to specific people, that can be done with the beneficiaries as well. So keeping a list of your assets with the named beneficiaries on the side with your will is definitely advisable. And like I had mentioned, looking at it every 5 years is probably a good idea. It doesn't necessarily mean that you have to update it every 5 years, but you should take a look at it. Just make sure that everything's still the way that you want it to be. And then don't forget about the updated times. Now we have what we call digital assets. So upon passing, who's going to close all these social media accounts? We can't leave them out there open because now we realize that, in fact, there are people out there that hack dead people's accounts and then start utilizing them. So we do want to make sure that we name someone who can go in and close out all of these accounts for us. So when you do work with an attorney, just please make sure that you account for the digital fiduciary to make sure that you have documentation so you can submit this documentation to whomever it may be if they do require documentation in order to make sure that things are closed. So going over the 10 common mistakes again. Make sure that you make a plan, document your wishes, make sure you nominate the guardians for your dependents. Consider a trust if you would like to make sure that assets stay in your lineage and are not subject to divorce or lawsuit. Planning for any taxes that may exist, avoiding probates, looking at long-term care and how that's going to affect your estate, the income in respect of a decedent. Do I really want to leave the majority of my 401k or IRAs to my children? If I'm in a lower tax bracket in my retirement than my children are while they're working, then you should pay the taxes. Maybe if your children are in a lower bracket than you are in your retirement, then maybe you can pass it on to them. But those are a couple of things that you want to take into consideration. Making sure you keep your beneficiaries up to date, and of course, don't ignore the digital assets. So with that, I don't know, John, if we're going to be able to send out the evaluation forms.
Yes, indeed. All participants of this session will be emailed it.
Okay, great. So we can send the evaluation forms to everybody. Please do me a favor, folks, and just fill out the evaluation form, and you can email that into me, and my email is on the next slide there, because this tells us how I'm doing, and this is also submitted to the University of Maryland so they can see how I'm doing, and if it's good, they keep bringing me back for different sessions in different departments for University of Maryland. Also on this sheet, if you do want to speak with me about something personal, then you do have the opportunity to put that on the sheet, and someone on my staff will contact you, and then I'll set up a meeting and answer any questions that you have. So with that, I have my email here. I believe my email is also on another sheet that has been provided to you, so you can always email me with any questions as well. Okay, so with that concludes my presentation. Are there any questions?
James, thank you. Yes, we do have questions. I appreciate that you can understand why I bring you back as an overview lead-off session every year, because you really cover all corners of estate planning. We're now
I do see the questions. I can answer them if you like.
Sure. First, I'd like to, James, if I'll give you one that was posed during registration, if that's okay, and then we can move on to some of the questions that were raised. This, excuse me, sorry, wait till the truck backs up. This was from registration. The question is, Maryland law requires an in-state representative of the personal representative designated in the will does not live outside of the state. What is the reason for that, and how are they chosen and compensated?
Okay, so I'm going to be honest with you. I have never heard that before. I know of many situations where their representative of the will was in fact outside of the state. So that's something that should really be asked for our next presenter, who's the attorney. Mm-hmm. But okay. I honestly have never heard that in regards to a will or for a trust documentation. Because it would be, logistically, it's almost impossible for everybody to have somebody in the state. Many of us, most of our family members are all over the country. So that's something that I would follow up with the attorney on.
Okay. Would you like to select your own question, or would you like me to give you a question that was asked during the session?
Well, I see the list of questions here. So one of the questions was that I have one child, so do I need a will that one child will get everything? And my answer to that would be yes, because again, it's not just the will. I realize that the will is stating who your rightful heir is, and we all know who the rightful heir is, but still yet that will has to be walked through the probate court. So it would make things a lot easier if in fact you did have a will. And don't forget that those other documents you absolutely want to have, even though we know that your son is going to be the personal representative, the power of attorney, they still need to be named because those documents need to be presented at the time of those services. So yes, absolutely, I would still have a will and all of the accompanying documents. The next question is there a standard HIPAA release form? That would be done by the state. So if you live in Virginia, I would look for something from Virginia because they can have some additional stipulations there versus Maryland. So yes, I would do it by the state. Where can we find the online will link? That is, I believe through Maryland, you all had some resources in regards to sample wills, right? Is that right, John?
No, that's not right. Sorry.
Okay.
We do have some resources on our
That must be, yeah. There are different departments in Maryland that, believe it or not, have a few different resources. You know, if you look online, there's like all of these different online companies now that offer will services. So you should really take a look at that. I think that's probably the best way to go. Then here, let's see, what if there are no spouse and no children and no living parents? That's a really good question. At that point, you have to think of any charities that you may have. And if you do have charities that you want to leave something to, again, it's still important to make sure that your assets, you know, go to the right person. If you have no idea where you want your funds to go, you can always speak to John McKee, and there's always the University of Maryland, right?
Yes.
That you can leave assets to. But again, I would prefer, if I had no spouse and no children and no living parents, I still would want to make sure that my assets go to specific charities of my choice rather than just going to the state of Maryland. And again, part of that question is, where do the funds go if you don't have? Then basically it would be like abandoned assets, and the state of Maryland would end up taking control of that. So if everything is in the pod, and other similar status, what is used to pay for any estate or inheritance taxes? Okay, so if you have an estate and you have, let's say you have a transfer on death or payable on death, which is what we're looking at here. So the assets go to, let's say, my son. And so the question is, well, if my son has all the money, then who's paying for the estate taxes or whatever the case may be? Well, it's unlikely that you can have everything that goes directly to heirs through beneficiary designation. But in fact, yes, without a doubt, if there are no available funds, then things would have to be sold in order to pay those taxes. If you don't have things that can be sold, then if there's any debt or whatever the case may be, they're going to go after those items that were listed as beneficiary designations, because that was in fact part of your estate prior to passing. Not clear the difference between a will and a living will. Again, the will states who the rightful heirs are and goes through the probate court. The living will is really in regards to whether you want to be kept on life support, fed through a tube, etc. And there's a thank you here. You're very welcome. Revocable versus irrevocable trust. Very, very good question. So a revocable trust. So many people say, well, you know, I have a trust, or I'm going to put something in trust name, and well, it's over here in the trust. But the reality is, a revocable trust means I can end the trust whenever I want. It's completely revocable. So that means it's in my name and my still tax ID. So it doesn't do anything for me right now. What happens is when I pass away, it becomes irrevocable. So the irrevocable trust is, again, like I stated, its own tax ID. So technically, with an irrevocable trust, once that's established, then I, who developed that trust, can no longer make changes in that trust, such as who the beneficiaries are or how people receive them. If I've retired and I'm living in another country, you know, again, that depends on where you're keeping the assets. Many of the countries have reciprocal tax agreements, and that's the case for income taxes And then if you have any assets in the U.S. that are above the estate tax limitation, then of course they're going to try to go after, the IRS is going to have to go after that to try to get their estate tax money. Don't have minor children, have sufficient savings and sufficient retirement savings. Is it necessary to have life insurance policies? Wow, these are really good questions. So that really depends on your situation, because again, in that situation, you're not getting life insurance for income protection, because generally younger people, that's why they get life insurance, because they want to protect the future income, right? But for estate planning, life insurance is absolutely utilized, and not term insurance, permanent insurance, because it has to be there when you pass away. So in some circumstances, people will use life insurance for estate planning because the death benefit is income tax free. Okay, it goes to the beneficiaries immediately, and it gives them liquidity to pay for other things, so they don't have to sell investments or whatever the case may be. So yes, it can very efficiently be used for estate planning, but it's not a necessity for income replacement. So the way that you view the life insurance and what you're utilizing it for is very different now. Let's see here. How does this affect my will or wills? I'm not quite sure what you're referring to on that one, so I'm sorry, I'm going to have to skip that. I have all the necessary documents. My husband refuses to complete the basic documents if we should die together. Will they follow my wishes? Okay, so yes, both of you need to have those documentations because you're both individuals. So what you can do is you can try to create, most of the time, like if I have a power of attorney, my spouse has a power of attorney, but they say the same thing, except for the fact that we're first power of attorney for each other, but then the next person in line, next person in line, and next person in line are all the same. So the documents do need to be separate. I'm not sure if co-documents can really be made, and some documents can be done like that, where other documents may not be able to be done like that. But without a doubt, if at all possible, try to get them created and get your spouse to just go ahead and sign them. And I think that's really at the end of the day the best thing to do. What's the typical cost and timeline of walking a will through probate? That depends on how organized one is. And again, in some circumstances, I've heard that it takes over 6 months. And some people say that they get through it in a matter of a couple months. But again, there are things that you do have to do, such as notifying creditors, and there's a time frame that has to be out there. Should a wholly owned and paid for home, for which we have a deed, should that be in a trust? It can be. Usually, as far as putting assets like homes or real estate in a trust, attorneys may have difference of opinions in regards to that, but I always say, look, if a home is paid off, then sure, you can change the title of the trust name. Does UMB provide any will-related services to employees? That was no. But we are providing this education, so that's good. You showed us a slide of where not to die due to estate taxes. Is there any good place to die? Well, in regards to estate planning goes, any of those other states that weren't colored don't have separate estate taxes for the state itself. So any of those would save you some money if your estate was above the $5 million in the case of Maryland itself. My father, let's see, I want to die broke. Any advice to those who want to give everything away before they die? Well, absolutely. Again, that's why there are charities like the University of Maryland. They exist there, and they continue to function through the grace and benefit of people who do leave money. So that's something that's absolutely necessary, and it will always continue to be necessary. But there are a lot of charities that work exactly in the same way. But what you don't want to do is give money away prematurely. Because what if you need those funds for long-term care services or whatever the case may be? It becomes a little bit tricky in that way. So you definitely don't want to give it away too early and cut yourself short. Does my agency cover the cost if I create the will with James? Okay, so I don't actually create wills. As a financial advisor, I guide my clients on what they should have and what they need and what they don't need. And then then I send you off with that to the attorney. And I try to help you so you don't log as many hours with the attorney. So you know exactly what it is that you're looking for. But I can absolutely guide you in the right way to make sure that you clearly understand things even before you go to the attorney's office, or whether you're going to do it online.
James, I'm afraid that's about all the time we have.
Okay, well, I appreciate all the questions.
Yeah, well, how about you just answer one more question?
This one, can I set up a trust with your company? Again, I do not set up the trust through our organization. I do not provide legal work for you, but I do guide you on what needs to be done and help you coordinate that. I appreciate all of you attending. I appreciate your time. And John, thank you for bringing me back again. And again, everybody will have my email, so they can continue to email me any questions. Fill out the evaluation form for me, please. And you can always set up an online or call by filling out the back of the evaluation form. So thank you very much, everyone.